May 31, 2023 Compukram Examsim 85%, Property Ownership and Land Use Controls and Regulations. Question: which of the following is not appurtenant to real property? Correct answer: outbuildings. Not. Deed of trust. Rationale: outbuildings do not automatically stay with the land. A deed of trust is a mortgage in some states, and is appurtenant to the ownership unless steps are taken to remove it from the title. Easements and mineral rights run with the land. Question: A and B take title together at the same time under the same deed, each owning one half of the real property. What form of co-ownership will law presume they have? Correct answer: tenancy in common, not joint tenancy. Rationale: to have joint with right of survivorship, joint tenancy in common, all four unities must be present: possession, interest, time, and title. Right of survivorship also must apply. Estate by the entireties is a form of co-ownership between husband and wife with right of survivorship, but has been abolished in most states. Because the question did not specify whether A and B have the right of survivorship or not, the law presumes tenancy in common. Question: which type of description is inadequate for describing property in a deed? Correct answer: house number. Not rectangular survey description. Rationale: an address is not part of a legal description. A legal description is one that would give a competent surveyor enough information to find the property and also to stake out its boundary lines. Laws of agency. Question: which of the following is not an element in an action for fraud? Correct answer: the defrauded and defrauding parties must have relied on a confidential relationship. Not the statement of fact must have been a material misstatement of fact. Rationale: there is no requirement that the two parties have relied on a confidential relationship. There is no confidential relationship between a buyer and a seller, but a buyer may maintain an action against the seller for lying. Question: an agency relationship can be terminated by. Correct answer: the principal revoking the agency relationship, not only by mutual agreement of the parties. Rationale: a principal revokes an agency relationship, while an agent is the party that would renounce the agency relationship. While an agency relationship can be terminated by agreement of the parties, this is not the only way to terminate an agency agreement. Valuation and market analysis. Question: which approach to value would be most appropriate when appraising a vacant factory? Correct answer: cost approach, not market approach. Rationale: unusual structures, where comparable properties are not readily available, will be appraised using the cost approach to value. Question: if a property has been renting for $750 per month and, based on comparables, the GRM is 110, what is the indicated value of the property? Correct answer: $990,000, not $82,500. Rationale: the indicated value using a GRM, gross rent multiplier, is the monthly rent x 12 months, x GRM. In this case, $750 by 12, x 110 equals $990,000. Question: reproducing a structure best describes. Correct answer: building an exact replica of the structure, not building the functional equivalent of the original structure. Rationale: building an exact replica means that the replica has the exact look and feel as the original structure. If a historical building were destroyed, the building would likely be reproduced. Financing. Question: you have written an offer in which the buyer asked the sellers to pay his half of the escrow fee and his 3 points. The sellers accepted $135,000 for the home and the buyer is going to put $40,000 down. How much will the buyer pay for his points? Correct answer: nothing, not $2,850. Rationale: read carefully. The sellers, not the buyer, are paying the points. Question: a lender advertises that there are reasonable monthly terms available for the purchase of a home. Which of the following disclosures is necessary? Correct answer: no disclosure is necessary. Not disclosure of interest rate. Rationale: simple statements such as reasonable monthly terms available will not necessitate disclosure under the Truth in Lending Act. However, a disclosure of a particular item, such as the interest rate or the monthly payments, would require full disclosure of all interest-related items. Question: the note that calls for payment of interest only is called A/N. Correct answer: straight note, not partially amortized installment note. Rationale: an interest-only note calls for the payment of interest only, or no payments, during the term of the note with all accrued money being due and payable on a certain date. This is also called a straight note. Question: who is the trustor, and what title, if any, does he or she hold? Correct answer: the borrower, who holds equitable title, not the lender, who holds bare legal title. Rationale in a trust deed: the trustor is the borrower. He or she holds equitable title while paying off the loan. The trustor conveys bare legal title to the trustee by way of a trust deed. Question: the deed of trust is considered to be, correct answer, security for the debt, not an instrument that conveys legal title. Rationale: the deed of trust allows the lender, in case of loan default, to order the trustee to sell the property. Thus, the deed of trust is security for the debt. Transfer of property. Question: who prepares the tax bill? Correct answer: the tax collector, not county tax assessors. Rationale: the tax bill, which assesses land and improvements separately but taxes them at one rate, is prepared by the tax collector. Question: real property may be transferred or alienated by all of the following except, correct answer, inheritance, not operation of law. Rationale: private grant, public grant, and operation of law, foreclosure, are all ways of acquiring title by transfer. Inherited property is acquired by will or succession. Practice of real estate and mandated disclosures. Question: what is a trust fund account exclusively used for? Correct answer: holding clients' money, not paying unsatisfied judgments against licensees. Rationale: California real estate law requires brokers to have separate accounts to hold money belonging to their clients. Question: an agent promises a seller that the listing will be advertised every week. The listing only makes it into 2 ads that month. The agent is guilty of which of the following? Correct answer: actual fraud, not negligent misrepresentation. Rationale: never promise more than you can give. California law says that this is actual fraud. Question: an agent advertises a property for sale for $120,000. When any potential buyer arrives for showing, the agent says that the price has just been raised to $160,000. The agent is guilty of, correct answer, false advertising, not price fixing. Rationale: the agent is guilty of false advertising, normally called the bait and switch strategy. There is no violation of any fair housing principles or discrimination based upon race, which became a protected class under the Civil Rights Act of 1866. Price fixing and market fixing are legal under the Sherman Antitrust Act. Contracts. Question: an option agreement is, correct answer, a unilateral contract. Not both answers. Rationale: an option is a fully negotiated unilateral contract in which the optioner, offeror irrevocably agrees to hold the offer open for a certain time in return for the option/offeree's performance of payments of the option money. While the optioner is obligated to complete the contract, the option is under no obligation to complete. However, when the option does give the optioner notice of intent to complete the contract, the option becomes bound and the contract becomes a bilateral contract with obligations on both sides. Question: seller Sue promised in the sales contract to have an expensive new roof put on the house before closing. At the closing table, when asked about the roof, Sue said she decided not to replace the roof but just to reduce the sales price instead. What can Bill the buyer do about this? Correct answer: either answer, not refuse to close. Rationale: if one party to a contract performs his or her side of the bargain as set forth in the agreement, the other party is required to perform. 2. If one party fails to perform, and the failure is not excused, he or she has breached the contract and the other party is not required to perform. Question: what type of contract is an option? Correct answer: unilateral, not bilateral. Rationale: an option is a unilateral contract between an owner and a prospective buyer to purchase or lease property within a specified time. Question: broker A conveys an offer from his client to broker B wherein A's client wishes to purchase a 300-acre farm by giving B's client $100,000, 2-year-old tractors and 50 head of black Angus cattle. What would the consideration offered by A's client be called? Correct answer: valuable, not good and valuable. Rationale: contracts must be supported by consideration, which is offered by one party to induce another to enter the contract. Valuable consideration is anything of value: money, goods, personal services or exchanged property, or often simply the promise to deliver something of value. Good consideration consists of love and affection and is sufficient to support a gift deed. Question: the commercial broker listed a storefront for rent. A tenant was procured. After the lease was signed, the owner refused to pay the listing broker. In order to get his fee, the broker could, correct answer, Lien the property, not file a complaint with the Division of Real Estate. Rationale: the commercial lien law now permits a broker to lien a piece of commercial property if he is under contract and has earned his fee, but the owner refuses to pay. This is not true of residential property. The broker would have to file suit in civil court to get his fees in a residential dispute.